Ebusuya mama kwaba sonko so the Ghana politics avenue so ebusuya mama yembo mra yensem. Ebusuya eye fast track justice eye tribunal eye speed eye court eye justice ya eye attorney general represented the koma eye parliament say omo de omo pass that bill no. Ebusuya eye chairman Wontumi lawyer and Andy Apiakubi ebusuya ewo TV3 or the nsɛm bi aba abɛto dwa ebusua ayɛ sɛ ehu bi abɔ ewura ɛyɛ lawyer Andy Apiakubi because ɔka sɛ ɔmo gye ɛyɛ that bill ne tum a ɛyɛ allegedly sɛ ne client ɛyɛ fɛn kyɛn ma Wontumi ebetumi akɔ jail because ebetumi aspidi ɛyɛ ne court case anaasɛ that ne Exim Bank ɛne Minim Forest case there a high court a bit may speed up ama watumi akɔgye nti nso ɛkasa against tribunal court bill no ɔno nso ɛkasa against ebuso mu yɛnkɔ tie nsɛm bi a anase ehu bi a abɔ Chairman Wontumi lawyer ba yɛde aka na bɛto so.
A regional tribunal shall have jurisdiction to try such offences against the state and public interest as Parliament may by law prescribe. So the expectation is that Parliament will bring out another law that will guide the performance of the regional tribunals. And in fact, the regional tribunals are given specific roles, not general jurisdiction as pertains in the district court or the regional courts, but by the Constitution is given a specific assignment, and that is why maybe reference is being made to trials under minerals and mining law.
And in fact, that's Section 11 that Lawyer Judgement-WATCH read in this particular bill.
Yes. Clause 11.
That's Clause 11.
Yes.
It's captured in Article 1443.
Yes.
Justices of the Court of Appeal and of the High Court and chairmen of regional tribunals shall be appointed by the President, acting on the advice of the Judicial Council.
So that is not even going to But let's look at the constitutional provisions. And again, Article 143 says that regional tribunals shall have jurisdiction. And you see, when the Constitution or the law says shall, it means it is foreclosed that it must happen. So for me, the matters of its establishment is a constitutional matter. Whether or not we like it as a state or as citizens or as Ghanaians, we may have to, then repeal those clauses of the Constitution, amend by way of amendment, amend the Constitution. But again, don't let us also forget that these are entrenched provisions, that it cannot be amended as of right of Parliament or any institution. It must be by referendum. Absolutely. You see, so if we want to amend a constitution as it speaks like this, then we must go through the process of amendment, and then we take it out. But not until that time. The constitution is ensuring that we do it. So if we want to do it now, I don't think that, for me, it is not unlawful. But if we are not happy with the situation, then we must go through the process of changing the provisions on the law. But given this opportunity to affect the legal system through the Constitution, let's look at Article 139 2D. And it says that the court shall consist of
139
The High Court shall be constituted by 3 judges of the court for the trial of offences of high treason or treason as required by Article 19 of the Constitution. So it says that the High Court can try treason and high treason. Now go to Article 143. The High Court shall have no power in a trial for the offence of high treason or treason to convict a person. You see, the same Constitution contradicting itself.
So what's the point?
You understand? So what I'm saying is that these two laws are contradictory to each other. And therefore, in the hierarchy of norms, when there is a provision that comes against another provision in the same law, the import is that the first one gives way to the second one.
Because
And
the
therefore,
whole idea is that the legislator knew of that before introducing.
Yes. So the first one will give
more or
way
less to cure a mischief
the
earlier.
So I am saying that this constitution, as you have it, has these two provisions contradicting each other, and for which reason it retires Article 1392D as non-effective.
All right.
And therefore, we will go away with that. Okay. Now, coming back to the tribunal system and the fears as expressed.
And the fears, yes.
The fears, regional tribunal. Yes. Because it's a constitutional expectation, we cannot fault it. But that is why there's a requirement of Parliament passing a law to effectuate the provisions under the Constitution. So Parliament has a duty to ensure that all the safeguards that will cure the fears of the public, and in this case, minority, make sure that these provisions are provided to cure.
And I think that they're already there.
But like I'm saying, no. It will be subject to debate. Listen, it will be subject to debate. But as Martin said, they are not sections of the law. There is only a bill there. So these clauses are only clauses to be debated in Parliament. So I will urge all of us to follow the debate critically, particularly members on the Constitutional and Legal Affairs Committee. They must show presence and do the debate. And again, when it comes to the plenary, the minority who have various issues with various clauses must be there and debate it and make sure.
But even before this bill is passed by Parliament, that fear of government or the NDC appointing its people on the panel to, as it were, prosecute opponents, is that fear not addressed already in the Constitution?
Well, they are not law yet.
No, I'm talking about
so
the
you
Constitution.
Could still have the fear.
No, I'm talking about the Constitution.
Okay.
Because if you read 1252, it says citizens may exercise popular participation in the administration of justice through the institution of public and customary tribunals and the jury and assessor system. 1443 says, 1444 says, panel members of regional tribunals other than the chairman shall be appointed by the Chief Justice in consultation with the Regional Coordinating Council for the region and on the advice of the Judicial Council.
Yes, so the provision is there already. So this is the provision that is being lifted into the new act.
So is there any basis for the fear that only NDC people will be appointed on the panel?
Well,
based on this particular provision I just
You see, unfortunately, sometimes when we start the debate without having gone through the existing provisions, because some of these acts, the sections in the act are provisions in another law having been lifted and positioned there. So if we are not challenging the existence of these provisions in this superior law, where is our mandate to challenge it in the lower law? The act is a lower law to this one.
Thank you.
So what I'm suggesting is that let's go in there, do the necessary debate, make sure the right things are done. But the institutions that are going to be created by this new law, let us see also that these institutions work to perfection.
Thank you very much.
Before the court.
Let's correct this.
But if it was
let's correct this. Let's correct this. You see, there is tradition order, all right? It's made by the district court. It's not the high court.
Yes.
So that order was made by the Basic District Court some months ago. So to go out, it's not a high court.
From Basic.
Yes. So let's just straighten it so that to make your argument stronger. So the district court, made the order that it should be extradited some months ago.
Right.
Then Oliver rightly went to the high court and got bail. So it stultified it.
And
so,
will this come first in the application for bail?
Yes.
To the knowledge of that court?
Yes. So, of course, you show the judge evidence that he's been, there's an order, he's been committed to be extradited, blah, blah, blah. So the High Court, Alawa, Bassett Justice Alima, right? Bassett.
Granted the bail.
Granted the bail, and that's good. It strengthened our system, okay? Then, some months later, you know, the Attorney General was hauled to the U.S. That's why I said it's in the side here. It was someone to the U.S.
He was hauled.
Yes, let's say it. Look, we are not joking. We are not Iran.
Do you know that he was hauled? Or there was
yes,
a visit?
we have
Because
to put it strongly. Then you will see that there's some. You see, we are not we are not angry enough. Look, this is a very serious matter. Matters pending before our courts, and yet you have our government extradite somebody. So it tells you that there is some force at play, something that's overwhelmed us. So let me just quickly. It helps. It's the facts. So the judge granted bail. Then fast forward, when the AG returned from the US, as I said, I don't know what we are getting in return. Then quickly they brought back the case record. Then the judge revoked the bail. Then Oliver now files again to hold the bail. So that's a stay of execution, blah, blah, blah. So that is what is pending. So the judge has revoked the bail, meaning that now you can take Abu Trika to the US. But Oliver is filed process back and forth. And that is what is pending and then still. So this is a rendition. What Ghana is done is not extradition. This is a rendition.
Let's go to the process.
That's what you disagree with.
Let's go to the process.
Yes.
Okay.
First one to the refusal of the bail or the failure of the bail application, whichever the case. Was there any appeal against that decision?
Exactly, all of those.
Was there an appeal against the decision?
That's what I'm saying. You can put Oliver on.
That will situate the stay of execution.
Oh, yes, basic. But that would be basic.
Right. Okay. If that was the case,
yes.
If there was a stay application pending, had not been taken, then one would presume that it ought to have been taken before the next activity of the extradition.
No, but was there a stay of execution?
Yes.
Okay, that's okay.
And you can put Oliver back.
I'm qualifying all my presentation if there was. Then, of course, procedurally, it was wrong for us to have gone ahead without considering the pending application. So that one, I agree with you. But again, I'm not also in agreement when you say that there was a return package for which we were influenced to take the action we took as a country.
Oh, absolutely.
You see, you don't need any motivation beyond the determination of the various courts to do that which was done. So I am not in agreement to say that.
So you breach your own laws, disrespect your own courts.
Please,
for nothing.
Please. I will not make a submission that I cannot justify. That there was something, the package waiting for Ghana. For his region, we had to do that. I don't know about that. I know
about that.
Well, so inform us. Let us know what American government had put in place for us to justify the
they call it quid pro quo. That's their word.
So if you don't have that information, in fact, in the year in 1983 thereabout, some Ghanaians were also extradited. And in return, we had some Ghanaians also extradited to Ghana. So that is a possibility, but I'm not aware of any such package now which will justify any such action. So I cannot speculate like that.
Don't call it speculation, please.
He doesn't know what you know. So
you see, and again, the district court would have granted that order to extradite. And you know, it is a possibility within our laws. And indeed, we in Ghana, we also have the Extradition Act of 1960, which is still in operation. And there are only two conditions that we need to satisfy for the court to make such a determination. And one of these is that whether or not we as a country, we have any such arrangement with the requesting country. And in this case, the answer is yes.
Yes, we do.
And whether or not it is not a matter affecting a political question. And the answer is no. And in any case, if we have satisfied these two preliminary conditions, then the court, and if there has been also an order from the receiving jurisdiction that there is a request for extradition, when these three conditions have been met, then the court would not ordinarily, accede to the request. So that is what was done. The only hinge about the process is the pending application, which I agree with Martin. So it could have. And again, I say that did that come to the notice of the court, of the High Court? So the High Court also haven't taken any decision in that. So if the district court was seized with knowledge of a pending application like that, then probably it would have withheld the request. Again, even if the request was granted and the action had not been taken, the Foreign Affairs Ministry would have said that, well, let's hold on, because he was in lawful custody. So let's hold on until this one is taken. And then in respect to our statutes and also in respect to our judicial system. So that one, I agree. There was no need for any rush. In any case, I'm not saying that the court was wrong in accepting the extradition request. It was in order. And again, we have this arrangement. And again, the question is not a political question. So personally, I think that nothing has been done. And in any case, I agree with Martin again when he says that the extradition order and then the extradition itself does not constitute any offense or any crime or any acceptance of commission of crime. So what we need to do is that he should be given the necessary opportunities and time to prepare his defense. And here, what I will advocate is for him to be given proper legal representation, for him to be able to defend himself.
As far as we do know, that is actually being done.
And again, in this case, at the expense of the requesting country. So, and don't also let us forget that he has a right to determine who represents him, even in the jurisdiction that he is not familiar with.
True.
And the state of the United States should give him the opportunities to also select the representation that he has confidence in, and so the cost of such representation be borne by, because of course, come to think of it, until he is proven to be guilty, he has not done anything.
As per the reports so far, his appearance in court yesterday, as has been reported, he had legal counsel. He had a lawyer, and he pleaded not guilty to those 2 counts. The detention waiver has been executed. A jury trial has been set for September 8, 2026.
When you say he was represented by a lawyer of his choice or a selected one, it's very important.
The information I have doesn't point to that.
Yeah, it's very important. No, but he has a right to refuse that one. And he has a right to select.
A lawyer of his choice.
Yes, of his choice.
Okay,
so the representation itself is not adequate to fulfill that expectation.
Well, Godwin Eduji Tamaklo is Chief Executive Officer of the National Petroleum Authority and a private legal practitioner in good standing. Lady Tamaklo, good morning. Thank you for joining us. Some of you who are not.
Alfred, good morning, and good morning to the religious sects.
Indeed.
You know, the people who listen to Key Point, it has gotten to a point of religiosity.
Indeed.
They more like a ritual for them on Saturday. Today, I'm sandwiched by my learned seniors today, and I strongly believe that I'll be. They will impact me with the received learning and from experience and everything. So, good morning to my learned senior Martin, Andy, and then Ambassador.
Say the small boy who washes his hands well.
Amen.
Eats with.
And then Ambassador, of course, Michael Quay. He's also. We are all in the same constituency, and when I was coming, I was listening to the radio, and he says you'll come again. He needs to pass the party, his party first, and come and meet the formidable Eliklem Akrugu. She's waiting for.
Did she tell you that?
Oh yes, of course.
Okay.
I'll respond accordingly. Thank you. He said you will respond accordingly.
Thank you very much. Right.
Yeah, but so this morning, and then of course.
When they are in Chechemua, a lawyer and the appeal could be every children ever tribunal court bill, a attorney general at the call, say, and common pass, but I say, who be abato a lawyer and so say, on so cassa again, say, Omoje da bill ni tuma, a dear. Yeni client Wontumi bit to me, I could jail, the Sintino, was Omonia Botre, and my bill no bede, Omoede, a debate, and found myself my pass. The business on subscriber and not subscriber, no one share, no one is on his kitchen bed, so am I. Send me my political airline, so I need to be about the Damasi.